special features of private company. Most of the provisions of Companies Act are not applicable on the private company. Majority of the provisions only applicable on the public limited companies. Section 3 very clearly define that minimum and maximum number of members in a private limited company. Minimum 2, maximum 200. That's clearly defined in section 3 of the Companies Act 2013. And 103 that relates to quorum of 2 persons unless article of association provide more. Quorum basically relates to how much minimum number of persons required to declare any meeting as a valid meeting. In case of companies, we not act even a single action, we not take even a single step without the meetings. Meetings are essential part in case of companies, either the meeting of board of directors, either the meeting of members. So, in case of meeting of members, how much minimum number we required to declare any meeting as a valid meeting, that is known as quorum. And quorum here define minimum 2, and if article of association in the favor of more than 2, then this condition laid down by article of association is applicable. Then this condition of 2 is avoid or ignore this condition of 2. And simple logic behind the same, when we constitute a meeting, we required minimum 2 persons. One person never constitute a meeting with himself or herself. For create a meeting, we required minimum 2. Section 149, to declare any association as a board of director or to constitute a board of director, we required minimum 2 directors in case of private limited company. To constitute a board of directors, minimum persons as per section 149, minimum 2. Limit on maximum managerial remuneration of 11% not applicable on private limited company. Generally, section 197 of the Companies Act 2013 define 5 to 11% limit on managerial remuneration, but this limit is applicable on public limited company. But this limit is not applicable on private limited company, and 5 to 11% here of a net profit, not a gross profit. So, in the in the discussion of directors, we discuss in detail how much remuneration required on the part of private and public. Section 153, rotational retirement condition not applicable on the directors of private limited company. In case of public limited company, 1/3 director retired after every year. That is the requirement, and rotational retirement system is applicable on public limited company, and as per section 153, private limited companies are exempt from this provision of rotational retirement. Provision relating to manner of filing of casual vacancy not applicable. It means total discretion of the private limited company how they fill up the vacancy. There is no any rule applicable on the same. Section 161 applicable on public limited company. Section 164 deals with the disqualification of directors. Section 164 deals with the public limited company, but a additional disqualification may be imposed through article of association on private limited company. That is the total discretion on the part of private limited company. They may impose any additional disqualification for their own directors, but in case of public limited company, we are bound to follow the rules and regulation as laid down in the Companies Act 2013. Section 165 that's fix the limit of maximum number of directors simultaneously. At the same time, you act as a director in how many companies, that's defined by section 165. No person can be act as a director in more than 20 companies same time. Out of these 20 companies, a person cannot be director in 10 public limited companies. It means two type of restriction here. One, you are not act as a director more than 20 companies, but out of these 20, only 10 allowed to be a public limited company. Section 149 again, private company exempted from requirement of independent director in board of directors. This is the concept of good governance here. Every company is bound to appoint some number of independent director in their board of director, but this condition is applicable on public limited companies. Being a logic here, in case of public limited companies, money involves to the public money involved, and central government is the guardian of public money. So this provision of independent director inserted in statute books due to protect the public money, due to remain vigilant or be vigilant to protect the public money. So central government through this act, through good governance rules, inserted this clause. Every public company is bound to appoint some directors from the group of independent director, and they are supposed to be give impartial advice as and when company required, or on regular basis when board of directors meeting call, they gave their impartial advice. Section 177, private company is not required to constitute audit committee, but in case of public limited company, this is an essential requirement. Every public limited company must constitute a audit committee, and this is an important committee. Some committees are very important. One is CSR committee, another is CRR committee, another is audit committee. So audit committee play very important role in the functioning of a company. So these all committees we constitute as per the requirement of law, and section 177 exempt the private company from the requirement of audit committee. Private company may issue shares other than equity or preferential shares if memorandum of association or article of association in the favor of this one. That's totally depend on these documents. If these documents in the favor of that, this company issue which type of shares, then there is no need to be take permission from any agency. They issue, being a private company. Section 62, no need to keep its right issue open for minimum 15 days. Otherwise, in case of public limited companies, this issue must be remain open for 15 days. So many issues here, but I highlight here one concept of right issue here. In case of right issue, we offer the shares to existing members. Their right become first, and generally this right is known as preemptive right. Preemptive right, and this right goes to first those who are already members in a company. So in case of right issue, you no need to be remain open this issue up to 15 days. Otherwise, this is the condition in public limited company. Section 141 define a person shall be eligible for appointment as an auditor of a company only if he is a chartered accountant, firm of chartered accountant, or LLP not allowed. Who is a chartered accountant? That's always an independent person. This particular section 141 clearly define that Audit should be made by independent auditor, and chartered accountants are considered as independent auditors. Section 184, interested director. This word may be create doubt in the minds of students. Who is an interested director? Interested director basically means who have their interest in the company, either pecuniary interest or managerial interest or administrative interest. If any type of interest of a director involved in the company transaction, we presume that there is no any impartial advice given by this director. The actions of directors are manipulated actions. So, interested director can participate in the board meeting after disclose his interest. Particularly in case of public limited company, interested directors not participate in the functioning of company, but that's allowed in case of private limited company after disclose his personal interest. That's clearly refer in section 184. ESOP, this is a new concept here. Employee stock option scheme may given by ordinary resolution in case of private limited company, and through this scheme loan for purchase of its own shares allowed. Generally a company not grant the loan to their members or the directors for purchase their own shares, but this condition relax in case of private limited company. Exemption from filing board resolution to registrar of companies, that's also here exempted. Loan to directors subject to certain conditions. It means loan also granted by private limited company to their directors. Generally this is not allowed in case of public limited company. And what type of powers exercised by directors? Provision of section 160, 162, 180 relating to appointment power restrictions are not applicable on private companies. All restrictions are applicable on public limited company. Before start this discussion, I already explained before you, majority of the provisions of Companies Act not applicable on private limited company. Being a reason is here, the money of the public not involved in private companies. Private companies arrange the money from their own sources, and public money apply in case of public limited companies. Journal body meeting section related to section 101 to 107 and 109 are not applicable on private company. Again, it means these provisions only designed for the functioning of public limited company. And another controversial issues here, either a company accept the deposit from public or not. Deposit from public basically deals by section 73. Deposit from members, private company allowed to accept deposit from its members as per section 73. How much? The limit is here up to 100% of its paid up capital and free reserve. Free reserve and paid up capital subject to information to ROC in prescribed manner. Free reserve basically assets of the company, and capital is also up to some extent that's the asset of the company, but particularly this asset is available for doing the business, not for any reserve purpose. Free reserves we create from the profit of the company in any financial year. If company earn the profit and after distribute the profit among the members in the form of dividend, if any money remain, that should be transferred in the free reserve account, and this free reserve account may be used for in specific regions or for specific purposes. The signing of annual return in case of startup company, annual returns signed by directors are accepted. Otherwise, this return signed by company secretary. If company have a company secretary, then that officer sign on this return. Otherwise, in small companies or startup companies, the sign may be accepted by directors. Board meeting basically indicate that startup private company may hold only one meeting of the board in each half of the calendar year. Gap between two meetings is not less than 90 days. This particular provision only in the favor of startup companies. Interested directors shall be counted towards the quorum for a board meeting. Either meeting relates to member, either meeting relates to board of directors, we required quorum in each and every meeting. And how much quorum required here? That's depend on article of association. And if article of association in favor of more persons, then that is treated as quorum. Otherwise, generally minimum 2% treated as quorum in case of private limited.